Civil appeal stands dismissed.
I'm requesting for listing on 4th, the IA filed seeking stay. Execution has been filed before appellate tribunal.
Have you admitted the matter?
We have, my lords have admitted the matter, my lords. And expedited hearing also. Now they have filed executions coming up on 15th. I'm requesting only IA to be listed on 4th, my lords.
We don't want it.
Notice has been issued on the IA.
Second.
My lords, it's already notified for 2nd. Constitution bench would be sitting on 2nd, my lords.
Some other court, let it go. Not necessary to go it for us.
My lords, on 2nd.
802.
My lords have put it on 2nd, my lords, before different combination. Great.
Lordship, item number 802, Lordship, for mentioning. Lordship have directed to 5th March list the matter for final disposal of 20th May, Lordship. But Lordship, several times the matter were listed but deleted, Lordship. I am humbly requested, Lordship, whatever the next date, Lordship, kindly matter have not deleted, Lordship.
Date then. We'll give you some date.
Lordship, highly obliged, Lordship. Highly obliged.
Yeah. Oh, Sabrabhi Bhattacharya, one of these matters are coming. Some date now. Yes, item 3, 803. Give some date. No orders. Next.
Your Lordship, this is a proper fixation of pension. The petitioners are in the 80s now. Some of them have even expired.
I'm appearing in item 803, mentioning minutes.
What happened?
Minutes, requesting for listing of an IA which was.
Okay, we'll give some date.
In 804, Your Lordship.
Yes, 80. Kuch date de dena. 804.
804, Your Lordship, these are retired pensioners, the former income tax officers. They're now in the 70s, 80s. The litigation, the matter has been stayed. Delhi High Court has been stayed by this Honorable Court.
Hearing expedited. Next.
805, my lord, September 24. Your Lordship, there is an order to list on before chamber judge. It hasn't come up, my lord. It's almost a year, my lord.
What matter is that?
This is a Lodha and Birla dispute over the estate of the lady Miss Priyamvada Birla, who died, and her assets are now leave granted. Assets are with the administrative.
Don't tell us that.
Your Lordship, leave granted and interim relief has already been declared.
No, madam, what do you want?
My lord, we are saying that some people have died in the meanwhile.
What do you want?
We want a listing of the main matter, my lord, and
Okay, hearing expedited.
but there is also, my lord, an application for deletion which has been filed that is not getting listed. I was only requesting if that could be listed. At least the parties could be deleted, and at least the
status was 4th of September, my lord.
Sorry. Next.
Lordship, may I mention IA number 183662 and 183682
So many mentioning.
in civil appeal number 13301 of 15.
Why don't you put it up in the mentioning? Don't make oral mentioning.
I only bring the matter be listed along with the main matter.
Everybody does that. Follow some pattern so that we will know. Follow a pattern. Don't just make oral mentioning. Next.
Lordship,
Something.
yes, Lordship, there's a mentioning the matter was listed on 25th. There was a particular observation of condonation of delay. The order sheet is there. It's not reflected in the order, Lordship.
Mention. What is it?
But Lordship had orally had condoned the delay, Lordship.
Doesn't matter. The notice will go in a delay petition. Can't be expert.
Then, Lordship.
Lordship, may I mention item 57, Your Lordship? It is included in the supplementary, Your Lordship. I am seeking on Monday, Your Lordship, the matter.
Adjournment.
Yeah, adjournment till Monday. Other side issue that
Okay, all right.
We came to know only today morning.
All right, all right. No issues.
May I please your lordships? Malad-
For respondent number one, my lords, it's Autumn Investment that we have taken
Malad-
the respondent number one, Reliance Finance. So we'll be filing an amendment application as well as a reply in 2 weeks. My lords.
You are for the respondent.
Respondent number one.
Malad, I'm for the
You
petition.
transfer it.
No, my lords, I believe I don't have a copy of the petition. We'll just,
What is it? Every cause of action, everything has arisen there.
no, my lords, I believe,
Huh?
though I don't have a petition, my lords.
Complete abuse for you to file there.
No, my lord, but I believe it will be covered by the Sindoor Agro judgment of Justice Pardiwala.
What
This
judgment?
two Sindoor Agro and Oil Industries versus Kotak Mahindra Bank, my lords. 2025 SEC Online, Supreme Court 508. My lord, just kindly otherwise give me 1 week's time, I'll file.
All right, next week, next week. Online, S25 SEC online page.
508, my lord. Sindoor Agro and Oil Industries.
Have a look at that judgment.
Great.
Next week,
Much obliged.
Grateful, Malad.
Monday week kar lena. Not on Friday, Monday week. Yes?
May it please your lordships.
Who is for the state?
I pay for the state.
Tell us. How much time was he inside? It's a 302 case
Yes, your lordships.
with SC/ST allegations.
There are 12 witnesses.
Charge sheet is filed 1.5 years, but then what's? Huh?
For last 1 year, he is on bail, my lord.
1 year.
Bail was granted, it was cancelled on his behest.
Because there are 2 FIRs of.
You're for the state.
I'm for the state.
What do you say?
If the matter is listed for charge, there are 12 witnesses. And
He did the High Court.
his motorcycle was seized from the spot. He has, if your lordship sees my counter, para
What
50.
purpose will be served by sending him back again? Unless there are some other incident.
Main आहे सगळं तिथलं kingpin आहे. But I am for the complainant.
No, not, we are sorry.
Counsel
What
for
we can do is, we will confirm that
Please
order passed by the trial court granting bail. And then that condition which was imposed, that he shall not go to that district, that we will confirm.
To stay out of the jurisdiction.
Stay out of the.
till completion of trial.
That's right.
Unless it is required for trial, my lord.
You are
Trial.
online. Of course.
Plus
Please.
even
Is that all
there
right?
are 2 FIR
Very
laws
well.
threatening the witnesses. And at the same time, Lord, state's counter says he has not submitted
Then
bail bond.
then state can.
No, my lord, but
the
He has
state to
not even
reapply.
complied with the bail conditions, your
We
lordship.
will,
He's
we
not
will, we
given
will
the bail
permit the
bond.
state to apply in the event. He violates. Okay? The court wants to lay them. Appeal against the judgment and order dated. So and so. Original appeal number so and so. They can first page number so and so dated so and so. The trial court by its order dated time, the issue relates to FIR filed against the appellant, leave granted appellant on 24/1/2024 with respect to first paragraph may have facts related on the basis of which the appellant was arrested on 25th of January 2024. It is also important to note that even the charge sheet came to be filed on 31st of March 2024. Paragraph on the basis of an application for grant of bail in April bail, the trial court considered the matter and by its order dated 9/5/2024 granted bail subject to following conditions. That you take those conditions which are there. Granted bail on so and so. As against the order granting bail, the respondent number 2 filed an appeal seeking cancellation of bail on various grounds. And this led to the order passed by the High Court. Interim order passed by the High Court. The interim order is order is extracted here in under. Report कर लेना. Interim order. Having considered the matter in detail and also reviewed and also taking into account the fact that charge sheet has already been filed and the trial court considered the matter and granted bail on 9/5/2024. We are of the opinion that the High Court should not have cancelled the grant of bail. Stop. In the facts and circumstances of the case and taking into account the concerns of respondent number 2, while we allow the appeal and set aside the order passed by the High Court, we grant bail, we direct that the appellant may be released on bail, subject to such conditions as may be imposed by the trial court, which will also include the direction of the High Court in paragraph number 14, paragraph number 14 as extracted here and above, which is a direction that the appellant shall stay outside Basmat Nagar Taluk during the period and report his whereabouts to the investigation officer.
During
Also
the
the trial court.
This restriction shall however not apply, will however not be applicable as and when the appellant will be required
during the
trial.
Grateful.
Okay. With these observations and directions, the civil appeal stands disposed of. All right.
much of.
Milords, in item number 3, Milords, before my learned friend start, Milords, Mr. Pratap Venugopal, who's been doing this matter for SEBI, Milords, he's on bed rest, Milords. So I'm requesting for the matter to be kept back after 2 weeks.
Punjab proposal will also take some. What happened? Yes.
Take some time, Milords.
Because it involves potential purchase of land properties. I have.
We'll just postpone this.
Yes, my lords may list it after 3 weeks is my request.
Adjourn by
Just one request, my lord. Let it be adjourned, my lord. Just that some applications have been left out to be listed today, my lord. Can we give the numbers to the court master?
I'm joining the same request.
Well,
Deeply grateful.
Right.
Listed.
Let notice go to the
Exactly.
because otherwise then again next time they'll come and take
Milords, may I request the matter be taken up after
Category
4
one
weeks
is
in that
listed.
case?
Who is appearing for SEBI?
Milords, I'm appearing, Milords, for SEBI.
Take notice in those applications.
Correct.
So and so takes notices in applications.
Yes.
Issue notice, so and so take notice.
Great.
But in the last quarter, all the applications are mentioned.
Just one submission.
Good day, ma'am.
I'm Surekha Raman, Milords.
Takes notice on behalf of SEBI.
Just one
Grateful,
submission.
grateful.
Deeply grateful.
Order, your lordships had mentioned those IAs. So those can be listed for hearing on someday. That's
No,
otherwise everything else
If
gets
the
added.
Punjab matter is the same.
Milords,
There are about 10-15 of them.
If the
How
Punjab
many IAs we can take up?
No,
My
no,
lordship
today-
clarified in the last quarter.
let Milords some.
The way everybody answers to our question.
no.
Asked, Patnagar, you just asked.
Yes.
They're not, they're part of one same category.
How many IAs can be listed?
There are a total of, let's say,
We will ask them. How
No,
many?
Milords, in fact, Milords, your lordships had on 2nd August by the order said that, certain applications would be listed. And on the last date also another 4 applications were added to that. So today only those applications were supposed to be taken up, Milords. And your lordship said you'll
What you
take up.
do is,
there are 22 in all, 22.
other applications which we have noticed and you are taking notice in those
Please.
matters. You examine them and we'll give another date.
Please, Milords, please.
Those which are listed today.
Exactly.
Will come immediately after 3
That's
weeks.
what I was.
2 weeks, Milords, if I may say.
This also concerns the same subject.
On 29
After
July,
4 weeks.
Very easy. Your lordship's last order.
Last
Your
order
lordship
is
have
different.
given the IA numbers as category 5. Let those be.
That's what I was
listed
submitting.
together.
Both categories, well, so category 1 and 5. We are requesting.
Not-
You know, please go only by that category 5, otherwise there'll be 100 IAs.
that's, those applications which are there
I
today.
just said what is listed today.
Very well, very well. Right,
Deeply grateful.
right.
Said once.
Yes.
My lord, 29th of July, my lord, I
May-
directed
Well, on 29th of July, my lord had directed 4 IAs to be listed. Number is there, my lord, but they have still not been listed today, my lord. Number is already mentioned 29th July, my
We'll
lord.
have to devise something for these, you know.
Well, it's in fact, some of the IAs
No,
are
there is already order for listing, my lord.
Concerned about the fact that so many of you on behalf of your clients and standing here asking for a date, the minimum that we can do is to give a date and hear you, which we are not able to do. It's very sad. So something we'll have to devise. You will have to tell us in which manner.
Because in fact, the list,
The entire bar waiting for.
well, in fact, your lordships had categorically listed only certain IAs today, my lords. So let those IAs be taken up, my lords.
Then there must be some mechanism where
Entire list,
do one thing.
please, my lords.
Take out, analyze all the interlocutory applications, categorize them,
My lords, it's already been done.
categorize them. Give us tentative dates.
Please, my lords.
Okay? Give us tentative dates on the next date.
Please, my lords.
We are not on the main matter. God only knows when the main matter is. Give the tentative dates and circulate it
Well, they don't-
or put it up on the website after you show it up. So that people will know when their applications are coming. Okay?
Please, my lords.
So systematically, we will take.
Please.
We will take perhaps,
Those applications are listed.
1-2 applications we can take every week.
Please, my lords.
We can take about 2-3 applications at the most. If you all cooperate, we will take about 5 minutes, 10 minutes maximum. So week after week, we can take.
Yes, sir.
2 applications.
That's right, sir.
To work on it, sit with them.
Because in fact, the entire list of IAs categorized as per what are the directions.
Don't want an answer, just work on the
Well, let's-
system.
we'll do that. Definitely, my lords. We'll do that.
We are trying to work out something.
We'll
Like
do
just
that.
hold your horses.
Yes.
We will try and.
Because we'll
My
take-
lord, suggestion would,
Give us a list of, those IAs.
Yes.
Only you come to the court and then give us that.
Please, my lords, we'll do that.
Give us that.
Ultimately, my lord,
My lords, the only,
very well.
There's only
Let's see
one.
How we can do it.
Very well.
certain
Check
IAs
with
have,
them if there is an urgency, prioritize them. Okay?
let's, we'll do that also. There's only one submission, my lords.
Last order says so, my lord, that they can sit with us and after.
There's
the
only
proposal
one
is
submission, my lords. Certain IAs are being filed and are being mentioned, my lords. We are not getting a copy of that.
Give copy.
So at least,
You sort it out.
my lords,
Give
we'll do
copy.
For today, it is on grounds of urgency because already only the sales certificate remains to be issued.
Check on that.
My lords, I'll,
Check on that.
My-
3 weeks perhaps is too
let's
late.
let them serve the application on us.
Started after 2 weeks.
If your lordship may list it after 2 weeks, my lords, between 18th and 26th, there's some difficulty.
You
Venugopal, sir,
have
just-
served those which are of absolute urgency, not on your idea.
Please, my lords.
On the basis of what the bar members are asking where there is an urgency, please understand their concern. And then, shall we have it next?
After 2 weeks, my lords, please, my lords, after 2 weeks.
Be issued by
It doesn't matter, we are there, we'll protect you.
My lords,
My lord, your lordship may give a specific date, my lord.
Because, sir, what more can we do?
Well, let's take it. Not issue the sales certificate. If
No, I think your lordships have fixed it. I think on that day will come and will not one by one.
That's right, Mullah, that's right. One by one.
This seems to be workable solution.
We will take up all matters, please.
Right?
I filed an application day before yesterday. Let that application be also listed, Lordship.
Give it to her, give it to her.
My lord, ultimately, my lord,
Thank you,
that
thank you,
may-
Suresh.
Lordship wanted a proposal, how we can sort it out, there's an IA which is
Wait, we are trying to see.
my lords, ultimately, my lords.
All right, call the next case.
Well,
obliged.
Call the next.
My lords, your lordship has given a date, my lord.
Rajiv Kumar?
There are quite a few IAs and each one will have to be considered separately, my lord. Though your lordship
Yes.
asked last time, my lord, that they will, because we will say about what each of the IAs.
Is there an amicus in this?
No, Mullah, that's what I was suggesting. Lordship should appoint someone.
Why don't you both help us?
Mullah, of course, Mullah, I am also appearing for the state of Punjab, but
You will become a junior for a short period.
no, that of course, Mullah,
Junior to
that's a
Mr.
privilege.
Rajiv Kumar.
That's a privilege, Mullah, I would say that.
Both of you, okay? We request Mr. Ranjit Kumar and Mr. Pradhan Rasat, senior counsels, to assist us in ensuring that these batch of matters are disposed of in a proper manner. You want assistance of some advocate on record?
Yes, Mullah, I will give the names, Mullah.
Okay, you give it, okay? Okay, Mr. Rasat will give the name of an advocate on record to assist them as well as the court. Okay, we will see that some fees is also paid.
No, 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 please, no, that will be, no, not at all.
You can give it to the bar.
Not for me also.
You can pass on the fees that we.
No, that
you-
was AOR, my lord, may
Arrest
consider
it.
after the work is done, my lord. Your lordships will see what's done.
Process it. Now, you won't be able to handle it. I think with them, some kind of a semblance of, some system you develop. You suggest some system where we can perhaps take up either the applications or substantially the main matters and then dispose.
Milord, may I also request that
Please now don't interrupt.
We'll prepare the note, Milord. We will, all the, whatever is pending, once we get all the papers from there. And after doing that in a consolidated manner, we suggest, Milord, in what
Suggest
way.
what to do.
Please.
You call, you ask, tell Mr. Pratap Venugopal to
Please, my
get in
lords.
touch with both of them.
Please, my
And
lords.
they will, and all of them work together and then tell us.
Please, please.
Devise a method by the.
At least 10 or 15 applications per day.
We'll just see that it is.
Because
This can't go on like this unendingly.
Right, so.
my lords, because ultimately, my lord, most of the applications, my lord, the title is involved. Ultimately, my lordship may have to delegate it because these people.
Also, very, very important. I want both of you to apply your mind on this. Why should the Supreme Court be the nodal agency to deal with this?
Precisely.
A minute. What we suggest to both of you is just examine whether under IBC, the matter could be sent there for them to take up under a particular jurisdiction, or whether it could go back to SEBI under its jurisdiction, or we can entrust it to a particular district judge.
Well, it's already
Nominated,
interested.
yeah, something like that.
Because
Just-
NCLT, RERA, SAT,
Trusted
all those are
milords.
possibilities we are examining.
RERA is there.
Yes, I'm examining, milords. I'll sit.
Milords, in fact,
we'll
this
see
matter
what
is
best.
already a district judge who's appointed, who's been looking into all their objections, etc.
With them.
Anyway, let them come back.
Come back.
Thank you.
Let's-
Very good.
And we will listing it after 3 weeks.
Milords, Milords,
We will now impose costs on you if you repeat that. You said that. You should have some discipline when a judge.
Milords, I
is to
have-
resolve it.
well, it's a small request, Milords. Your lordships may either list it after 2 weeks or after 28th of September, Milords. After 2 weeks, Milords.
Great.
Very good.
Those-
There is
Thank
a
you.
new IA, my lords, 196544.
Now there is a channel for you to work. There is a channel.
Milord, I had to move that application, Milord, but now
My learned friend had to move it, but your lordship has now deployed my learned friend.
That's all right. That's absolutely a privilege.
You have put it on his shoulder. That's how, we have to take the
Only thing is.
participative bar.
Fine. We have given an alternative scheme. So, my lord,
You also join them, please. Join and then see what's the best way. They're saying, just suggest to us what's the best way. Thank
Grateful,
you.
milords.
Right. Next.
Grateful.
Just
Oh.
issue notice on this.
Yes, notice. Take notice on it.
Applications.
Same.
Item 4.
In our case.
Last time your lordship is we should
Note master उसको जाके बोलना एक दरवाजा खुला रख के बोल. Send somebody, keep one door open. One of these doors.
Are you an
Side door.
item 4?
No,
Item 3, my lord, 1 IA, my lord, let them take notice. My lord, already the property is attached by, in consequence to an order by the state.
What happened? The bail matter, no?
but they.
But if I may be allowed to circulate the IA.
Item 4.
But item 3, my lord,
Item 3 is
my
over.
lord, item 3, my lord, the IA number your lordship issued notice, my lord. The property, my lord, that put in auction notice, my lord. My lord, my only ask is till next of your status quo be maintained. That's
My lord,
status quo, my lord.
my IA, let them take notice.
Or else, my lord, the 35 crore of the investor money has to go and attach, my lord. This is only till date of hearing next status quo, my lord.
In which item? Call her, what's that? Sureka Raman. Some status quo order he is asking.
Milords, nothing can be passed today, Milords. In fact, the committee is not taking any decision now. Your lordships may keep it after 2 weeks.
My lord, not committee, my lord. I am not complaining against the committee, my lord. UP, the housing board is going to forfeit the 35 crore rupees investors amount and auction the property, my lord.
So I'm not aware of it, Milords. They have to tell me.
Your lordship already issued notice.
Restore it back, Shekhar, don't worry.
My lord, just, I'm sorry, my lord, just took time to,
Phone?
item 3-1, took time to,
No.
took time to reach you, my lord, sorry.
They've already passed.
No, but just-
Please now let us proceed further.
My lord, just.
Item 4.
My lord.
No.
Why, I tell lordship, there are a bunch
No,
of.
then don't tell us, please. We will tell you that now. Item 4.
Wait, please.
I'm item 4, madam.
I'm for the respondent, no.
Here in the order, there was some technical difficulty. So only word withdrawal was required to be recalled because there was some interdependent problem. Some other matter were pending and so.
Other copy I couldn't find.
22 is the page only what withdrawal is required to be.
Lord, I am opposing this. No, that's at page
22,
22 of the
25.
MA. Page 22 of the MA.
Only withdrawal word may be removed.
Withdrawal. No, just see the dates.
We dismissed. In modification of our order, we, this special petition stands dismissed. Withdrawal mat likhta, bas dismiss kar.
Very well.
Only.
Great.
Delay may be confirmed.
Delay confirm. SLP dismissed. Modification. Client aake pakde.
Your Lordship, I appear for respondent.
There's a letter. 6, there's a letter. Item 6. As per letter.
May it please your Lordship. My Lord, I am at
It's
your.
a review.
No, no, it's not review.
Absolute review.
No, my Lord, we only want, my Lord, those observations, my Lord, if your Lordship could please consider. Because, my Lord,
Review. Not even, we can't even.
no, we are not asking for any change in the order.
Brother Sanjay's order.
My Lord, correct, my Lord, that is true. But if your Lordship pleases, my Lord, we can.
While a review, we'll consider. Nothing more.
My Lord, I am not asking for a change in the order. I only want your Lordship's, my Lord, to please, my Lord.
File an MA like that.
My Lord,
No, Mr. Where is it?
my Lord, both at the level of the institution and the individuals, my Lord. These words, my Lord, are really, my Lord.
Withdraw or dismiss?
I'll withdraw, my Lord. I'll
Withdraw.
My Lord, would your Lordship give me liberty to, my Lord?
It's actually very wrong to file this IA.
Lordship.
File a review.
All right, very. Your Lordship may observe.
Permission. Why there is no need? We'll consider your review.
All right, very well. Very well. Your Lordship, deeply obliged.
Right.
Wait, please. Lords, this is the EC that's granted for one of our projects. It's a completely different project from the previous one. Sanction is granted 7 years apart.
That's the law which applies to it.
So as far as the cumulative impact assessment issue, that's been left.
In Deepak Kumar.
Yes, no, but the question has been left.
How are you going to say?
Question has been left open in that, but in my view, those facts may not apply here because.
May not.
Yes, because there are many cases, my lords, where.
The law that applies.
It's the EC 2006 notification that applies, the EIA notification.
How, according to you, they can't be considered as a cumulative?
I'll explain. There are many cases of the high courts, NGT, etc., where, for example, you have a single project, which is a road. They break it up into 25-kilometer stretches and they make 4 applications. The court says, no, that you can't do. Ours are 2 completely different projects.
We'll issue notice, not that we are with you.
I appear for the caveat, my lords. I have only one submission, one factual thing which is not being pointed.
You are for whom?
I am for the caveator, my lords, the original appellant who had challenged the environment clearance in the Green Tribunal, my
I have a
lords.
list of the litigations.
These are 2 phases which are 500 meters away. Just 1 second, Mr. Shankanarayan. These 2 phases are only 500 meters away from each other. Very conveniently, SIPCOT does not even mention it in its EIA. That's a finding of fact.
As much, but we.
Apart from that, please see the dichotomy.
We've placed
On the
the
first
map
phase, we go to the. I can show it from the map itself, which is there in the synopsis. 500 meters away, you don't even disclose it to the authorities, my lords.
Shreyas, just listen to us.
Yes, my lords.
We are tentatively with you, but we will just examine the matter. We'll just issue notice. Take notice.
Very
well. I'll file a reply. I'll file a reply.
Yes.
Notice, that's all now. Will be appeal.
Well, there's a refiling delay that may be condoned. I'm great. No, that's okay. Some date your lordships will indicate because so these are big industries. Our projects get held up 1 year already. It's a 7-year EC that I have. So 1 year has already gone in this. I'm grateful.
List immediately after service.
Grateful. I'm grateful.
I'm obliged, my lords.
Lordship, this is contempt. Lordship, kindly have page 10. Direction given by your lordship has not been complied with. Page 10. Order dated 28th of January 2025. Willful non-compliance. Your lordship directed to pay within 5 weeks.
The matter.
Lordship, kindly see page 10. Page 10. This is the direction.
He just said that.
Yeah, lordship.
You go and execute your order.
Lordship, kindly have the page 10. Lordship.
While we are not inclined to take up the contempt petition, the petitioner is at liberty to execute the order of the National Consumer Dispute Redressal Commission dated 19/5/2010 as upheld by us in our order, by our order dated 29/1/2025.
1996, I have paid the money.
Closed.
1996, Lordship.
Go.
Lordship,
Get it
executing court maybe give you a time frame, Lord.
executed. You are flogged. Thank
Give
you.
a time frame to execute. Otherwise,
Right,
it
go
will
and get
take
it
around
executed.
again, Lordship. Give a
Thank
time
you.
frame
For the
within
next case 9,
within 5.
item 9.
My lords, this matter needs to be tagged with SLP number 14113 of 2024.
What are you saying?
This matter needs to be tagged with already existing bunch matters. The lead matter is SLP number 14113 of 24.
So post along with that. But this arises out of what?
My lords, all these matters concern that the report or the red entry in these matters.
That we have seen the repetition as against that is come. And so
Right.
far as this is concerned, identical, is it?
Yes, my lords.
Why is this come with a delay of 350 days?
My lords, we were facing issues in finding the copy of the reports or the red entries, which is why this issue has arisen. Obliged.
10.
My lords, these proceedings are,
Seeking for pass.
your lordship,
May.
your lordship, this is a fresh application, your lordship.
Will posted for Amanu. What dated 10/7/2024, comma, and 27/2/2025. 27. As Amanullah as दोनों में दोनों में 10/7 and 2024. The registry may take instruction to the Honorable Chief Justice, CJI, to place the matter before the bench decided by Justice Amanullah. We'll post it
Yes,
before
sir.
Justice Amanullah.
Obliged,
He has
sir.
passed the orders.
Obliged, my lords.
My lords, may I request for a short pass? Then it is chief.
DBI. Pasova.
My lords.
Pasova. Yes, Mr. Chahar.
My lord, in item 12, the Honorable High Court has directed us to renew the liquor license of the country liquor shop of the petitioner. Now the problem, no, my lord, what had happened was he had two shops.
Bhajan Purva.
Yes.
Or Duswa.
Yes. So, my lord,
Kheda.
yes. Let me explain the two SLPs first.
What's the difference?
The difference is, my lord, out of these two shops, the shop concern of the relevant matter. This was a shop we had raided, and we had found that he was selling.
Same principle applies.
But in the other shop, nothing was found. It was only on an oral complaint we had suspended his license for that shop. That was rightly set aside by my lords up to this court. But in this case,
True, there are. I don't know why the High Court has done it. Because country liquor and false caps and
he was selling liquor,
and
spurious liquor and all. But my lord,
the High Court said that it is compoundable.
I have another problem, my lord. This license was under the 2018 policy. Now in 2025, we have an entirely new policy. So a license under the 2018 policy cannot be renewed under the 2025 policy.
Is over, but what is it?
But my lord, as per the direction of this of the Honorable High Court, we technically cannot renew a license of under the old policy because the new policy is in place. We have already auctioned the shops under the new policy. We are willing. We are willing to refund the balance license fee.
That principle will apply even to that matter. Yes. To Gairav Kheda also it applies.
My lord,
We are stuck with the fact that in earlier SLP was dismissed,
But my lord,
more or less.
the earlier, the liquor shop in which the SLP has been dismissed, that has been re-auctioned under the new policy now. No liquor shop under the
That was. Then how did they do it despite our dismissal then?
My lord, under the, we have re-auctioned under the old policy.
The challenge now.
Under the new policy.
They've tried to get over that by auctioning it when the matter, your lordship's High Court had also granted stay. Nevertheless, they filed they gave it in auction to another one, the earlier SLP, after getting it dismissed.
That was challenged.
That is challenge that's pending in the High Court and the stay has been granted, my lord. So they are now trying to get over that by. No, because they are saying there is a new policy after the impugned order is passed. So they want to rely upon that will apply.
You want to
prospectively
follow the same thing.
Yes.
You follow the same thing here. This also you put it to auction. They might challenge.
We
it,
have.
sustain it.
We have already auctioned it, my lord.
Then what?
But my lord,
Then your stand would be.
he has filed a contempt.
Irrespective of whatever might have happened here, by virtue of the subsequent amendments of rules,
Yes.
you will be entitled to auction.
Yes, my lord.
We'll keep
That's
the-
an
we'll make the
independent.
position clear.
Yes, my lord, yes.
Lordship need
We'll
not
make
say
the
that, lord. Nevertheless, my lord. No, then that will deprive my rights because I'm already, my writ is pending there.
Listen to that.
No, then I will,
In view of the fact that similar special petition.
my lord, it's a prospective rule. It may not be applicable to the present one.
1 minute, please.
Yes.
Dismissed on 29/7/2024. We are not inclined to interfere with the order.
Yes.
The subsequent decisions taken by who are you? By the
State of UP.
By the state will be considered and decided on its own merits.
Very well.
As per the new policy, my lord.
On its own merits.
My lord, unless my lord's right policy of 2025.
Contention of Mr. Shehar.
Yes.
Learned ASG. Learned ASG on the basis of the new policy.
Very well.
That High Court will consider, nothing more.
And the new policy.
We can't judge it. Next.
Actually, my lord, we have already re-auctioned and he has already taken a shop
Your order.
in his mother's name.
Sustain your order in the High Court. Next.
May it please. But here is a case where petitioner has been condemned unheard. Lord, he, just because he was the managing director. Lord, your lordships time and again keep passing such order.
Saying nothing.
Lord, I'll just,
Interfere.
no, let me just place the case on record.
Nothing.
I was the managing director. I was not even in service in 2017 when such a decision was taken. I am the top, my lord, IAS officer of the state, a blemishless record of 34 years, my lord. Today, because of this impugned order, I'm sought to be punished without being heard. Lord, please consider this. When I went to the High Court, I was not a party in person. Lord, the other person, the respondent filed a writ petition for refund. Lord, the refund with interest has been given and this 5 lakh also has been given by the company. Where is it that, my lord, the managing director, your lordships time and again passes order? If there is,
Accountability comes.
my lord, when there is an erring official, there is an inquiry conducted. It's just behind my back. In one line, my lord, they say managing director. How is it sustainable, my lord? Their company will have to see.
Nothing would have.
I only followed the instructions of the tax consultant of not refunding, my lord.
High Court on the order, you are a party to the proceeding.
And I'm not, my lord. Please see this. Please see this, my lord. A chairman and managing director, a cut and paste cost title will not give me. I have never argued it in my personal capacity, which is what the High Court said if he came. And then, my lord, if it says, my lord,
To Mona, we are not interested.
my lord, when I just take this, my lord, because next is, my lord, the next level of post promotion, everything gets affected because of this. Please make it clear, my lord, this has no aspersions on his service or the
Of course it is.
integrity or anything. My lord, he has not done anything. Let me just show, my lord.
This is what the concept of accountability.
Please see 130, my lord. 130, it's a collective decision of the board. How can a single person, not collective decision of the officials who take it, my lord? What happens to a government servant? Can he be always under the threat of a Damocles sword hanging on his head for taking decisions? My lord, this decision was taken on legal advice. If I don't follow the legal advice, I will be in for a service disciplinary action, my lord. Now, when I take a decision, the court says you have taken a decision. Today, if it is found to be wrong, Lord, if a decision is wrong, that is appealable. And he got that appeal, my lord. Interest is awarded.
Not inclined, no.
Where is the question of managing director being liable, my lord? Allow me, my lord, there is no hearing which has taken place. Lord, can I just go on? Lord, this review has not decided on merits. It only says because I was a party, my lord. But this is not a case, my lord. Lord, with great respect, my lord, I must say, place his credentials.
No, don't
Lord,
insist.
can I just file an affidavit showing? Just one thing, Lord, his credentials will have to be seen, Lord. For an officer like this, it will be very demotivating, and not for an officer, Lord, such as this, who has not done anything from his, there is no malafide. There is no allegation against him. Nobody is making any case. Lord, I'm so sorry, Lord. This is not a case, Lord.
In execution,
Lord,
doing the duties need not balance.
Lord, it's not that.
Seriously affects citizens.
No, Lord, it is not that. Lord, if there was anything to be held against him, malafides are to be attributed. There is nothing, Lord, against him. Your Lordship's orders are there. Judgments say, if any government files a case with a delay, or any mistake is happening in a government office or a corporation, erring officials will have to be inquired into. Lord, here we don't even know who has done that.
Under which act?
Sorry, my Lord.
You are in your own anxiety.
No, my Lord, I'm just saying.
Even here to us.
No, sorry.
This action is under which act?
Yes,
we are asking?
there is no such enactment which is relied upon. It is just one line order while allowing the writ petition. Please come to that, my Lord. Yes. Please come to that order, my Lord. Page 82.
Under the Electricity Act, right?
Yes. No. Income tax liability. Lord, what happened? The income tax was to be kept back because there was an appeal pending against us. So if the liability was to be
Was the managing director
of this JVNL, not the electricity company. Therefore, what happened? The liability was, as per the tax consultant's opinion, my Lord, it was deducted. As my Lord, can I place the opinion and my decision, the decision paper, not by an affidavit? Kindly put it up next week.
now?
Lord, can I just put, Lord, let me file an affidavit and show how the decision was taken, my Lord. Lord,
Next.
Lord, kindly see the order by which,
Right, we have seen it.
Lord,
Leave it at that.
just this
I
one
don't
line.
think
Lord, I would like to show how the cost has been imposed without any consideration.
Dismiss with cost quantified.
Very well, Lord, I leave it at that. Lord, it's already a cost that he has suffered.
right.
It's not about the money. It's about, my Lord, the integrity of the person.
Again,
Lordship may say this will not come in the way of his, but kindly clarify that, my Lord.
not necessary.
Otherwise,
You will have to defend it there.
very well.
To protect our citizens. Thank you.
But this is not a case in my humble submission. Obliged.
Wait, please, Your Lordship. But one judgment of the High Court Division Bench is now being followed. Your Lordships on the last occasion at page 144 said question of law is kept open. Now the same thing is being followed. Somebody outrages the modesty of a woman. He suppresses that fact in his verification role. And after that, my Lord, he...
Notice.
Not
We have given another judgment, myself and of course, that's a judicial officer.
Yes,
Avtar Singh is not followed in that.
Police constable.
Very strangely, only in police selections you will find people with a, in villages, you know.
What he will do, my Lord, if he comes back and then outraging a modesty.
Reality, you will know, Mr. Ranjit Kumar. In villages, what happens? People don't even go to their village because, you know, some kind of a threat will happen. They will end up filing FIRs. But there are 4 cases against him. Issue notice.
Not interim stay, my Lord. The direction is to appoint. There is a direction that I must appoint at page number 23. Lordship is grateful. There is some delay in refiling. 8 days. Please.
Item
There are two matters, my Lord, both the matters.
Matters already been heard by both sides. Oh, that's all right. But
The petitioners, my Lord, I think we can ask for.
I don't.
Similar matters we have.
Yes, please see the order. Please pass the order to their lordship.
Request your pass over.
Pass over.
My lord, please take that. Your lordship's last order is there.
We know that. We know that.
No, the order was after hearing Dr. Singhvi and me. Your lordship said no error on fact or law.
Coming on this side now.
No, because on my appeal, your lordship said, no, it's a very well considered judgment, no mistake on fact and law. It was not an in limine dismissal. Your lordship says, after hearing both of us.
True that they are talking now.
You only request your pass over, my Lord.
Favor of that period is what they say.
Not period.
My Lord, grateful.
Period and the rate of
argue.
I know.
My Lord, we're seeking
You
pass
take
over,
the
my Lord.
pass over, take your pass over.
You argue, actually, you are ready. We will not.
No, I'll take a pass.
Why? Why do you have to protect Mr. Singhvi?
No, my Lord, I'm not.
We don't need to protect his fees. Now, you tell us. Tell us about this April 2019 to March 2021. Have you not relinquished that?
My Lord, I'm humbly requesting for a passover. The reason is...
Tell us.
My Lords, please, my Lords, may permit us to take a pass over. My Lords will.
Argue then.
My Lords.
My Lord, I'll just start. whole basis of the impugned order.
Ah.
And there is an affidavit I filed on 27th of September 2021.
Please.
Stating that I am relinquished.
We know that you are ready. Just don't worry. Next.
Often they are disadvantaged by the instruction of their client.
I know that.
Who won't allow, and who will fault them afterwards.
Item 16, Millard. Delay of 109 days, Millard, not condoned by the State Commission and High Court, Millard. The reasons for delay, Millard, the petitioner bank, Millard, did not receive the.
No need for dismissed.
Millard.
Not a case for.
No, kindly appreciate, Millard. This is the bank, Millard. They have done all the.
No,
made
sir,
all
sir,
the.
Not a case for insurance company.
Yes,
Who can't be weak part committee.
Because of some procedural issues, Millard, they escalated the matter to the higher authorities. They deposited in time, Millard. In time, Millard, immediately after knowing the matter, Millard. Lordship may consider, Millard.
Similar matters. We have discussed similar matters. And why? In view of the fact that
My lord, may I submit, my lord? My lordship has dismissed, my lord, the main matter, my lord, on which this impugned order has been relied over, my lord. My respectful submission is, my lord, because once my lordship has dismissed the main matter, it is very difficult for my lords to take some other decision. But, my lord, there is a fundamental error, my lord, in the misinterpretation of section 22B, my lord, because it is creating a lot of problems, my lord. My lord, then, my lord, may I request, my lord, to keep the question of law open, my lord, because everybody is relieving, everybody is asking relieving, my lord, instead of tendering resignation.
All right.
Asking.
We will dismiss it on delay. That's a better thing to do. Dismiss
My lord, the delay has been condoned, my lord, in the main matter. My lord, the delay may be condoned because some delay in my office.
Question of law.
The delay may be condoned.
All right, we have kept the question of law.
I'm appearing in 58. There is a delay of 141.
Grateful, my lord. Grateful.
58.
Item 18.
18. 18.
Item 18.
Item 18.
My lord, petitioner is a scheduled caste, my lord. Is that the land was.
Sale. How will you sustain?
My lord, the sale itself, my lord, the sale agreement itself void on the ground, my lord, there is a nullity. Degree is a nullity, my lord. Degree is a nullity. Kindly see the notice which I have received only after the dismissal of second appeal, my lord. Kindly see 2/4/2019 was the notice.
Complete abuse.
My lord, 2/4/2000.
As if you were unaware from 2009.
My lord, even
how much of proceedings you have undertaken?
My lord, even my consistent stand in the written statement itself is a government land can't be sold. Kindly see my written statement.
You have understood the question.
Well, correct.
That stand you have not taken for 10 years, but
no, Mela, I have taken a stand in the written statement.
Lost all that litigation.
No, I have
now
taken a stand.
Mela, saying that.
No, Mela, I have taken a stand.
About that fact that. Sorry, we don't need to argue.
Mela, I have taken a stand in the written statement. Kindly see the written statement for a moment. Kindly see the written statement. It is not the case that I have taken a stand for the first time. My consistent stand is the land is government. It is can't be sold. Only one prayer, this in the plaint they asked for alternative relief, the 50,000 rupees. I can ready to pay that around with the interest, kindly consider it, this is a scheduled caste land,
Not after.
There's an alternative prayer, there's an alternative.
1970. No,
not in 1972, this suit itself in 2013,
Thank you.
2013, kindly consider it,
Thank you, dismissed.
Please, my lordship, I had the occasion to deal with very similar matter in the Madhya Pradesh matter. Your lordship recall, my lord. My lord, 2-3 vital issues here, my lord. I'm for the petroleum refiner, my lord. My learned friend here appears for the person who wants to take the distributorship. My lord, number one, my lord, your lordships know that your lordships have frowned upon, my lord, giving a direction to either the
In one One case where Mohana had appeared, we have dismissed.
That's the one where I appeared, on the other side.
Case, I think we have allowed the similar matter. But then the norms are there.
That's correct. And we followed the norms. And on the norms, my lord, now the NGT is not happy with the norms. My lord, if you are not happy with the norms, my lord, can you give a direction to this, my lord, CPCB that frame the norms in A, B, C terms, my lord? Justice Pardiwala has clearly said, my lord, that this cannot be done, my lord. You know, some circumstances, perhaps, my lord, if there's an egregious problem, my lord, you can. Then what happens here? I'll tell you, lordship. But that's the order, my lord. Your lordships, I think, have had the occasion to see it, my lord. This is that Indian Oil Corporation versus VBR Menon, where, my lord, where the same Southern Zone bench said that these petrol pumps must also take a CTOE and a CTO, both a consent to operate and a consent to establish, apart from everything else. My lord, his lordship said, my lord, there are enough safeguards already built in by the CPC, by the 2020 OM, and, my lord, by the PESO guidelines, which both of you, your lordships, have seen in the other matter, my lord, which your lordships decided. My lord, so also kindly see here, my lord, there are 9 other pumps, and, my lord, I have no doubt that even in this case, even though, my lord, I have no direct proof, my lord, but the fact that it is being...
Always a presumption.
There is a presumption. There's a presumption. When, my lord, when they are so ably, my lord, when they are so ably, my lord, defended in court, there is always a presumption, my lord, that there is, I'll tell your lordship, my lord, there are nine in a row, and I want to put that on record, my lord. I have the entire Google map here. 9 in a row, identically situated, my lord, in terms of random residence up and down, in terms of the water table. Now, the water table, my lord, unfortunately...
What is reapply at a different place?
No, same place, my lord, same place. The PESO put me to notice after the gentleman complained. I gave my reply, and PESO, my lord, then cleared me. My lord, just kindly see, the one... Yeah. And I...
Notified residential area might be one thing, but people start living in some areas. It will affect people.
Absolutely.
Like the in other cases, though it was argued saying that it is an unauthorized colony.
That's right.
But then, we had to take a decision because of
the malafide I know, my lord. That's why, my lord, I'm not putting too fine a point on it. My lord, your lordships kindly see. That's why I didn't put too fine a point on it. I didn't put too fine a point on it. Here, my lord, there is no unauthorized colony also, my lord. What people do, my lord, when they wish to put up this kind of, my lord, application, they will then give it a self-styled kind of a society.
What's the error in the high?
My lord, straight away, the error, my lord, first, on the water table, my lord, the NGT has to, my lord, if the NGT had put to me that there is a high water table, which is only, my lord, first time taken in the rejoinder, I'll tell your lordship, yes, yeah, that's the one I want to answer. My lord, that's the one I want to answer. My lord, would your lordship give me one opportunity to put on record, because I could not do it, because in the rejoinder that came up for the first time, the NGT should have put this to me. These are not, my lord, those old-fashioned IOCL, BPCL kind of, my lord, underground bunkers. Kindly see, those... That's right. My lord, this is the first appeal, so I have no other recourse. So your lordship may... let me, my lord. I'm very grateful. I'm very grateful, my lord. Deeply grateful to your lordship, my lord. I'll put enough material for your lordship to see, my lord, that this might require your lordship's consideration, my lord. Because otherwise it's a it's a legitimate business activity, and the my lord, highways need it. I'm very grateful to my lords, my lord.
My lord, in the suit itself, they have given wrong boundaries and they have measured the land behind my back, my lord. At least notice has to be given to me, my lord.
Interim order, sir, injunction. Why should be?
My lord,
It's an
at
interim
least,
order.
my lord,
It's an injunction, interim order. Not a case for us to interfere.
my lord, suit may kindly be decided within particular time.
But they will decide. Thank. This will be dismissed. Next.
21.
Yes, my lords, I'm just seeking a Passover, that's all. Oh, my lords, I'm sorry. Yeah.
Plus 21.
Go back.
Let's, no, the delay is on account really
I would say they're poor farmers. They may not be poor, but they're farmers. But it's just because you receive money for compensation because the land is taken. It's the law is clear. Interest on the amount of money paid forms part of the original corpus and hence is not exigible to tax. We in under
Rejected in 2020,
Yes,
24/9/2020.
please. These are not people who are very well educated. They may be rich because their lands have been taken, but they're not people who are educated. And maybe some money can be refunded, maybe less interest, whatever else, but at least the money I gave mistakenly, thinking it was exigible to tax, should be returned to me. Government otherwise gets unjustly enriched. Some equities can be
circular. You relied on 9/6/2015 circular.
That is, says that you have 6 years within which you can make the application. At least one of the years for which I have asked for, 2010-11, was within those 6 years.
It won't apply to you.
So the point is that
You made your first representation in 2016.
2016. So the assessment year 2010-11 would certainly fall within the 6 years.
Even assuming that you made representation in 2016.
Yes.
4 years you take for a repetition.
But what do that's so if the department can take 4 years, that can be forgiven. But when I come back in 5 years saying that allow me also now to get the money, that is not the same standard must apply for both. And ultimately, these are, I repeat, farmers, and this issue is clear. They must refund the money.
Claim based
on the fact that this money that has been I paid tax on was on the interest that is paid on the enhanced compensation. Any interest which forms part of the compensation, it is our case, is part of the original corpus and not exigible to tax because you're acquiring. So interest and compensation are not revenue receipt. They are not. You can't tax them. So, but we, in our enthusiasm, paid tax.
when was that? The notices were issued when?
No notices were issued. There's self-assessment.
You paid tax in 2007.
6, 7, 7, 8, 8, 9, and 10, 11. Four different years. We paid tax.
And your repetition is 2020.
Because we made a representation, they didn't decide for 5 years. The department can take 5 years.
2007.
Some money can be returned without interest, at least the amount I've wrongly paid. That can be refunded. Maybe I'll forego the interest. But
you would have spent thrice the amount in this litigation.
The amount is very substantial, about 1 crore.
How much is it?
About 1.80 crore in terms of pay of the total enhanced. So I suppose marginal rate 40% would be about 50-60 lakhs.
Sorry, sir.
Obliged.
It is a lordship, Mala. But this is the foreigners tribunal matter. So my linkage document since started from 1954. And my name also appeared in the NRC matter as well. I submitted it subsequently, they filed an IA. So in this case, Mala, only linkage.
Completely facts.
Thanks, Mala. But your lordship on similar issues, your lordship has already.
No, those are.
But these are facts.
Wherever there is a marginal case, we do it.
But in case, my case, sir, my name is.
The High Court has very correctly explained it.
But NRC, my name has come up, Mala. If your lordship can see in my IA, Mala, page number 6.
No, we thought it was just dismissal on 226 initially, but it is not so. They have considered on the entirety on evidence.
Yes, but there is no appellate provision against this final tribunal because Reed Court has gone it. So, my lord, if your lordship kindly see page 6 of the IA, my name has come up because this honorable court has monitored this.
No.
So, tribunal's order is, my lord, if your lordship page 96. Page 96. Start from 96. Discussion page paragraph 6, my lord. Because these NRC issues, my lord, this has come later stage. This because my name has entered, because this honorable court has held it, is monitored. This honorable court has monitored in Writ Petition 274. As per this, I have filed the IA, my lord, if your lordship kindly see. Page 6. I filed separately, my lord. My name has been accepted. Yes. My name has been accepted, my lord, in this case. Page 6, my lord. This court, my lord, is monitored this matter. So I've given entire documents, my lord, everything as far as this monitored. So, my lord, in this case, my lord.
The complete consideration. Consideration. Tribunal. Evidence.
Page 34.
Proper consideration.
If you lordship, I'll satisfy lordship. Page 34 onwards. 1967, all documents is there. My grandfather's name is there. My grandfather and subsequently voters, everything is in sync, my lord. But because my husband is also a government teacher, government, my lord. He's a government. He's a government employee, my lord. So, but all this aspect, my lord, if your lordship is suddenly, my lord, if you're declared as a this, but because there is no appellate provision after that, my lord. So now question before lordship is that on an entire document I have given the leakage. How can I, because not as a single document, it's also got many documents, my lord. My lord, if lordship kindly otherwise.
Look, I'll raise three questions. Come to page 57, Miller. This is the order of the tribunal, Miller. Page 57, Miller.
Page 52. Why did you become ex parte before the?
Yes, Miller. Kindly see this order, Miller. The entire prosecution against
the balance in High Court.
Page 57, Miller. Is 7th or 8th line below is pursuant to the said order of the Superintendent of Police Border.
May 23.
Pardon, Miller?
Yes, tell us.
Borpeta, an inquiry was conducted by the inquiry officer who has recorded the statement of the witnesses, namely Mr. Ashaq Ali, son of such and Mr. Abdul Hamid Talukdar. Milord, these two persons are not before the court. They were never examined, Milord, and this ex parte were passed.
But that order which you are showing that went ex parte against you.
Yes, true, Milord. But why ex parte then I have explained, but otherwise I was
doesn't matter.
The entire prosecution was.
Let us see the opportunity you got before the High Court.
Yes, Milord. Then kindly come to page 58, Milord.
Yeah, High Court.
58, Milord. I was supposed to appear on 15th May 2023. Then the next date was 22.
We'll issue notice. Looks like you didn't get full opportunity.
Yes, Milord, only one submission.
Stay in the meanwhile.
She is in the detention camp.
Oh, she is in the detention camp?
Yes, yes. She will no coercive action be taken.
Status quo.
Wait, please. Just come to page 6 minutes. Page 6 of the impugned order. A genealogical tree given by me and a genealogical tree given by the vigilance cell. A stranger by the name of Gopala is put, and his progenies, their documents are used to non-suit me and my caste claim. In the review, I get the birth certificate of my cousin grandfather Gopala. Just have page 33. He was born on 19/12/19. And he expired, Milords, on 10/1/24 at the age of almost 5 years. These are the documents in review, Milords. The whole foundation of the scrutiny committee's order and the Honorable High Court should have gone.
There is no appeal against the scrutiny committee's order?
No, Your Lordships, no. I filed a review, therefore there is a delay. Just have page 33. The whole foundation goes. Page 6, Your Lordships, have the genealogical tree. Yes. Milord's vigilance cell goes on Dhangar R, the documents of this other Gopala. And it knows my grandfather's name. Everything is there. The whole foundation should fall. And I had three pre-constitution documents, two more which are 33 and 37. And Milords, it is
take out notice.
Grateful. There is a delay, Milords, because of the review filing.
Doesn't matter. Notice.
I'm grateful, Milords.
Okay. Can your answer sheets be tampered? Pass over.
Please, Lordship, I wait for the petitioner, my lords.
Rupesh, you are appearing for whom?
For
The passed over matter?
yes, NTA.
NTA.
Testing it.
26, Lordship. Lordship, I appear for the petitioner. Lordship, the agreement in question, which was entered between the licensee and the consumer, wherein this petitioner respondent was never supplied to the petitioner, my lords. And the respondent very casually in the impugn order submits that the document is not traceable, my lords. Without that document, we have an efficacious remedy before the UP electricity supply court. We cannot approach the court.
Contempt? In fact, what's your repetition?
Lordship, may I read page 44, my lords? For a moment, may I read page 44, writ order? Page 44, my lords.
Show us the
Lordship, page 44, the agreement in question, which is a crucial document, which was entered between them in 2017, my lords.
page.
Page 44, my lords, writ order, my lords. Writ order. Para 3, my lords, may I read? Shri Chetan Chatterjee placed the detailed instruction along with the last communication dated so-and-so, along with the office order dated so-and-so, and the bill dated so-and-so. Learned counsel for the petitioner states that the letter dated so-and-so was never served upon to the petitioner, nor the copy of the agreement has been given to the petitioner. Shri so-and-so, learned counsel for the corporation, raised an objection that at this belated stage, such objection cannot be maintained. Moreover, my lords, page.
Shows your prayer in the repetition. Did you say that please watch the bills?
My lords,
Copy.
please, my lords. My lords,
Shows your prayer in the repetition.
my lords, please, my lords.
My
My lords, page number.
I issued it a direction and unanimous direction respondent.
My lords, page number 34.
All that you asked is to provide a copy.
My lord, that copy was never provided to me. That is the most crucial document when you enter into agreement with the electricity board, wherein please, my lords.
Why did you ask that kind of a prayer? You should have said that the excess bills are illegal.
Please, my lords. My lords, after looking at the agreement, only I can assess. I've been paying all the bills, excess bills, penalties, my lords. I'm running a hotel, my lords. And the respondent very casually says in the contempt impugn order that the document is not traceable.
Understand how important the advocate's role is.
Please, my lords. Please, my lords.
Ask a wrong remedy.
Please, my lords.
Was the easiest thing for them to deny you the remedy.
Please, my lords.
Instead of asking for quashing the electricity bills, it's on there. It's the duty. It is their burden to say that their bills are justified.
My lords, the moment there was an inquiry held at the place of the petitioner, my lords. The moment I asked for the quashing, the entire supply would be cut. Just to run the hotel, I was paying the excess bill, my lords. My lords,
Still arguing the same thing.
please, my lords.
It will never be. You can restore your reputation.
Please, my lords.
You amend your reputation.
Please, my lords.
Ask for a proper relief to quash the excess electricity bills.
Please, my lords.
Ask relevant
Please, my lords.
prayers like give us the copy.
Please, my lords.
They are not in interrogatories.
Please, my lords.
Issue notice confined to restoration of the reputation. But then you have not challenged the writ. You have only come against the contempt.
Please, my lords. My lords, may I read?
All right, we will do one thing.
Please,
we will give you an opening.
My lords, may I issue notice the respondents would come to before my lords and place.
If they come, there is nothing.
My lords, they will provide the agreement. That is a confidential document, my lords.
Don't just argue blindly. In which way can we help you like this?
My lords, may pass direction with respect to the last para of the impugn order.
While we are not inclined to entertain the specially petition questioning the order passed by the High Court dismissing the contempt petition on the ground that there is no deliberate disobedience.
It was disposed of.
The order passed by the High Court. We are of the view that the petitioner is entitled to challenge the excess, the electricity bills which under which the appellant submits excess payments were demanded from him. While we dismiss the special petition, we make it clear that the petitioner will be entitled to challenge the electricity bills by an independent, by way of by adopting such remedy as may be available to in law. There could be, under the Electricity Acts, there is a procedure to challenge excess bills.
Please, my lord, you pay electricity supply code 2005.
There is also ombudsman under the Electricity Act. You could invoke even his jurisdiction.
In the absence
So
of
one of
agreement.
those remedies, we are keeping it open for you.
Please, my lord.
You go for that remedies and then do. Because we will not be able to help you in this contempt. Okay? With these observations, the special petition is disposed of. Right?
Yes, my lord.
It's the truth, unfortunately. What should I do?
Your lordship, I am appearing for the primary board inspection. I am seeking passover. I am led by Mr. Jaideep Gupta.
Lord, one is my contempt. Lord, these are those West Bengal 2022 batch where.
Lordship, I am seeking passover in this file 27. In the main matter, we have filed the MAM for the.
Lord, your lordship recollects the
Yeah.
IAs. Your
lordship, this is
clarification.
Yes,
What I'll tell your lordship.
Clarification.
What he wants to say is, originally there were 11,000 and odd vacancies. The vacancies were distributed in different categories. For example, they were spread over 4 language, Bengali, Hindi, Nepali.
So I am led by Mr. Jaideep Gupta. Will be here.
Who is appearing?
Senior advocate Jaideep Gupta.
Nothing, no clarification. Nothing.
Let
We
him-
won't need to do it. We won't even touch it with the bar.
Sure, sure.
Everything should be
Grateful, your lordship.
We made it more than clear.
Absolutely. And
Actually, we restrained from imposing costs on the board.
correct.
Hail come.
Egregious your conduct was.
And
egregious.
so we have moved a contempt. We are running after them. They have done nothing.
Not entertain your contempt.
No, Lord, contempt has to be contempt is judgment has to be complied. Lord, their application.
We left you a remedy for you.
So they have come here again to derail this process. That's the whole purpose of being here.
Before the High Court.
Yes.
Passover, I'll tell your lordship.
So the whole purpose is to derail and frustrate
No,
compliance
no,
of the
no,
judge.
we won't-
Yes, that will not
we
happen.
will
I'm
access-
sure. Yes.
Remedy, my lord, said for the people I am appearing for.
Yes.
Grateful, your lordship.
बहुत चला ये बहस।
My access to justice is denied in the same way in which it was denied to my client in the High Court. Millets.
Physical justice.
Here, Millets. 2 simple points, Millets. Millets, a fine of 5 crores for alleged illegal mining is imposed on me on the basis of an FIR which talks of obstruction of police officers, etc. That is still pending, no charge sheet filed. Admittedly, I was not heard before this fine is imposed.
That's a FIR.
FIR,
So charge sheet is not.
not filed. So this is the sole basis for 5 crore penalty. Admittedly, I am not heard. So I go to the High Court in the first round.
The principles of natural justice.
Now, therefore,
They dismissed that.
and they
allowed it.
concede straight away. They concede straight away that I was not heard and that they are willing to hear me. So kindly see the order of the High Court is important because I want to show non-compliance with that. And now the High Court says,
Penalty order
yes, ma'am.
was taken with the statutory under Rule 53.
Lordship, please.
That's not appealable.
It was appealable when that rule stood. It was appealable when that rule stood under Rule 57 without the requirement of pre-deposit.
Whole thing.
Then the legal regime changes. Now, that's why it's important.
What is it?
Now, my lords, it is 10% pre-deposit, which for 5 crores means 50 lakhs for an agriculturist in a neighboring farm. That is the onerous part of it. But before that, I want to show the complete defiance of the High Court order and for me to be relegated now to the same authorities who defy the High Court order. I am a neighboring agriculturist. I am a neighboring agriculturist. That means there is this plot from where sand is supposed to have been, or gravel millets is supposed to have been extracted. I am supposed to have sent my dump truck or whatever.
Was that order
let me show the High Court's order first. Can I,
Just show our conscience should be satisfied.
Lordship, please, my lord. One by one, I'll take my lords.
7th November 2020 order you show.
Lordship, please, my lords. I'll take my lords straight away to 7th November 2020. This is the order which has been set aside. Now, therefore, I'll take my lords to that. This is the order which has been set aside, so I'm taking my lords straight. Yes, my lords. Kindly see it's page 48, annexure P4.
Okay, you can show us at least the 11th of April 22.
Yes, my lords.
You can show us 11th April 22.
Yes, my lords. That is P9. Let me take my lords straight away.
77. Yes, correct. We got it.
Yes, my lords. Now, kindly see.
How do
It
you
was
propose
important.
penalty?
My lords, would your lordship give me just 1 minute? Before this order comes the High Court order, it's important, my lords, to see this. Before this order comes the High Court order. Therefore, I want to show the High Court order before your lordship see this order. Kindly see. Page 52 is the High Court order.
Point you're making.
The point I'm making is having conceded, having the state having conceded that we were not heard before this order was passed, the High Court orders, kindly see, bottom of page 52. Hence, the impugned order dated 7/11/20 is set aside. Please note set aside, birds. Because it was complete failure of natural justice not heard. The petitioners are directed to appear before the respondent on so-and-so, between so-and-so. Respondent will serve a copy of the show cause notice to the petitioners and will give due opportunity to the petitioners to file a reply and also. Minutes is not technicality, but
11th April order, show us, we will just consider that 11th April.
I'll take my lords back to that order. I'll take my lords back to that order straight away, minutes. The order which is passed after the High Court's remand. After the High Court's remand, kindly come to page 67. Page 67. The matter has been reviewed. Have your lordships got that, minutes? Their order has been set aside. Now,
Oh, this is
the,
what the order is.
the matter has been reviewed.
To notice.
Lordship, please, notes. In the meantime, we'll stay of recovery. Lordship, please. Great.
The arbitration clause is very clear that the two parties will nominate their respective arbitrators. The two nominee arbitrators will then choose out of the panel. High Court, my lord, it extracts the arbitration clause of a different agreement, and your lordships have held in court, each agreement is very different. Now, referring to a different clause in relation to a different party, it says, my lord, that since the arbitration is to be referable to the society, it must be deemed to be an institutional arbitration. But if I may show page 86 only for a minute. Page 86.
Court doesn't say that all this is illegal. Court doesn't say that.
But the court
But
now.
if there is an agreement of this nature. These kind of agreements we have protected, in fact, under court.
My lord.
Yes or no?
Please see page 41 only for a minute, my lord. Page 41 only for a minute. Now, these are the two agreements. My agreement is on the left side. My lord, my agreement is on the left side. The High Court refers to the agreement on the right side. Page 41.
Yes.
But if your lordship sees the left side, which is my arbitration, it specifically says, any dispute not resolved by amicably by conciliation shall be, please mark this, finally decided by reference to arbitration by an arbitral tribunal constituted in accordance with 38.3.2. So after the tribunal is constituted, next sentence says, such arbitration shall be conducted in accordance with the society, SAROD. Now 38.2 is at the foot of the page.
Who constitutes the society?
It's an independent arbitral institution. Sorry.
But there are two entities. The National Highways Authority of India is one entity. The Federation of multiple contractors numbering over 100 are the other persons. But I have no difficulty with the nominee being appointed out of that panel. I'm not having a grievance with that. So I nominate my arbitrator. I write to NHAI, please nominate your arbitrator.
Will be held in accordance with the rules of the society for affordable.
That's correct. Procedure. But I'm conceding to that.
Then what are you objecting?
My lord, please see 38.3.2 at the foot of the page, my lord. There shall be an arbitral tribunal comprising of 3 arbitrators, one of whom each party shall select one, and the third arbitrator shall be appointed by the 2 arbitrators so selected.